be tried? Sure. But that evidence can't be used. So law enforcement better have something else, okay? Now, there's some other limitations and some extensions to that that are really kind of beyond the scope of this class. But the one thing we know for sure is that evidence, right? Guns, dead body, cocaine, right? They can't be used against you at trial. Okay, now, so that was a federal constitutional right from 1914 to 1961. And in 1961, the United States Supreme Court incorporated that right to the states, right? And this was an Ohio case. That was actually a Cleveland, Ohio case, Matt versus Ohio. Actually, there are two big United States Supreme Court cases, each dealing with the Fourth Amendment in the 1960s. Terry versus Ohio being the other one. It's kind of fascinating. Okay, so with that said, since 1961, state law enforcement officers, right, have had to adhere to the exclusionary rule. Now, really what it was, the best way to look at it is that you're just telling police, hey, you got to have a warrant. You can get in and search, you just have to go get the warrant. You have to go to the judge. If it's after 5 o'clock, you go to the duty judge, right? There's always somebody on the clock, so on call, who will say, okay, tell me what you know. Is it a 51% standard? Sure, I'll sign it, and you go get it. Getting a warrant, frankly, folks, is just not that hard, okay? But nonetheless, you have to have it, and it's kind of a constitutional test for law enforcement, but again, not real hard. Okay, now, I'm just going to talk about two exceptions. Again, if this were, if it's a criminal procedure course, and of course I've taught before, we actually spend a whole month, right, looking at the exceptions to the Fourth Amendment warrant requirement. I mean, it takes that long, so we're just going through case after case after case. I'm just going to go ahead and summarize just a couple of exceptions. The first deals with automobiles. All right? Police do not have to have a search warrant to search an automobile. All right? Now you might say, why? Well, through several cases, the United States Supreme Court said, look, police may not have time, and cars are mobile. Things can be gone very quickly. A house, apartment, hotel room, those things are kind of there. All right? So I've kind of given something away. So whether it's a person's house, they own it, they rent it, doesn't matter, hotel room, residence hall, whatever, dorm room, they have to have a warrant. But an automobile, that's different. Because on a roadside stop, police might not have much time, right? Cars are mobile, they can leave the jurisdiction fairly quickly. Okay? Now, here's the curveball. Police still have to have probable cause. So maybe they don't have to spend the time getting the warrant, but they do have to have probable cause. Again, reliable evidence leading a reasonable person to believe that a crime has been committed, more likely than not. Okay? Now, you might say, well, Tudor, how in the world does this all come about? Generally what happens is that police think they have probable cause, they search a car, all right? The defendant is charged, right, using that evidence, and then the defense attorney will make a motion to suppress, right? And I say, well, what does that all mean? Basically what it means is that in a suppression hearing, police will actually have to state why there was reliable evidence leading a reasonable person to believe that a crime has been committed, more likely than not. So in other words, when police in a roadside stop are searching a car, all right, and they think they've got probable cause, in their head they're going to have to realize that at some point down the stream of the criminal process, they're going to have to defend that decision. Okay, and most of the time, frankly, it's very easy to do. Right? If you're pulled over for suspicion of DUI and you're slurring your words and you smell, okay, dead giveaway. You roll down the window, it smells like you've been hanging out with Cheech and Chong. You know, smell would be one nice part of probable cause. Okay, now with that said, let me change the facts a little bit, all right? And let's say you're pulled over by a police officer, or you're in the parking lot, it doesn't really matter, all right? But it's still an automobile search, and a police officer asks you, right? Asks, may I search the car? That means you know right away that police officer, he or she knows they do not have probable cause, all right? Now, one of the biggest exceptions, and it applies across the board, the biggest exceptions, all right, to the search warrant requirement is consent. If you say okay, you've waived Fourth Amendment protection. That applies to your house, hotel room, dorm room, etc. If you say okay, You've waived all Fourth Amendment protection. Then the police officer, law enforcement officer, doesn't have to worry about probable cause. Okay, so consent is just one of those magic things. It's kind of like the golden window of opportunity for law enforcement. Okay, now the second one is plain view. If there's criminal evidence in plain view, police can simply seize it. Okay, regardless of where it is. So let's say, for instance, police do a roadside stop. Defendant pulls over. Police officer's coming from behind, looks in the back window, dead body, guns, cocaine. Right? Okay. All of that can be seized. It's in plain view. Police officer didn't have to move anything over, move something around, open up a box, things like that. Let's say police come to your door. Right? Say it's a noise complaint. Right? Your neighbors are calling because you're noisy. Right? You're throwing a party, whatever. They come to your door, you open it up, they look inside, in plain view, dead body, guns, cocaine. All right? All of that would be admissible, no warrant would be needed. Okay, now, that's just a set of limitations, if you will, on the warrant requirement and the exclusionary rule putting them together, right? That there are exceptions, right? There are exceptions. Okay. Okay, now, let's go ahead and move to the Fifth Amendment. We'll spend some time here. Now, really, when you think about trial rights and post-trial rights, the Fifth Amendment is the first one that kind of kicks in, and then the Sixth Amendment. So, one of the things to think about, or if it helps you, when you're putting your notes together and you're preparing for the next exam, the framers kind of mapped out criminal process, right, in these three amendments. So you think about the investigations part, right? Well, that's the Fourth Amendment. The Fifth Amendment is investigations and trial, a little bit of a mix, and the Sixth Amendment is trial. The Eighth Amendment later on becomes, essentially what kind of happens after trial. Seventh Amendment just dealing with jury trials and civil cases. So we talked about that before, but it's kind of like, they kind of mapped it out for us. Okay, so let's talk about the Fifth Amendment, which has several rights in it, all right? And more narrowly, let's talk about the protection against self-incrimination, okay? Now, you've probably watched enough bad television, right, to see a criminal defendant being read their Miranda rights. Now, the Miranda rights have actually been around for quite some time, but they weren't constitutionalized until a 1966 case, Miranda versus Arizona, all right? So it's a state case, right, because you got a state name. Now, the question becomes, right, must law enforcement officers warn a criminal defendant of two constitutional rights, informing them of two constitutional rights before actually engaging in an interrogation of that defendant? Okay, so you've seen enough bad television, right, that there are essentially two parts to Miranda warnings, Miranda rights. One, you have the right to remain silent, all right, and two, you have a right to an attorney. Okay, now, if I'm a police officer and I'm arresting somebody and I want to ask them questions after arrest, okay, I have to let them know they have the right to remain silent, which means they don't have to answer any of my questions, and they have a right to an attorney, all right, not only right then and there, but also throughout the process. Okay, now, let's say, however, I arrest the defendant and I don't want to ask him any questions. I don't have to read him any rights. Let's just say, look, I'm going to arrest you, I'm sticking you in the jail, and that's it. Yeah, you don't have to give them Miranda rights, right, or issue them their Miranda rights. It's only if you want to interrogate. Now, curveball for you, right? Certainly something you want to get in your notes. The exclusionary rule comes back into the Fifth Amendment, right? We introduced it in the Fourth Amendment. It actually comes back in the Fifth Amendment, right? And let's say I arrest somebody. I don't issue Miranda warnings, right to remain silent, right to an attorney. And then I start asking them questions and I get some, yeah, I did it. Dead bodies in my basement. Guns over here. Yeah, it was me. All right? I can't use those statements against the defendant. Okay? So again, the exclusionary rule comes back into play, right? So something you should know about the exclusionary rule, it applies to two constitutional rights, the Fourth Amendment and the Fifth Amendment protection against self-incrimination. Okay, now, if you look at your outline, I've kind of got things broken down into basically pre-arrest and trial. Okay? Now, you always have the right to remain silent. Okay? So let's say a police officer comes up and says, I want to ask you questions. You can always remain silent. You always have the Fifth Amendment protection against self-incrimination. You just don't have the right to be warned unless you're going to be arrested. See the difference? You can always remain silent. You just have to invoke it on your own. It's only when you're subject to arrest you have the right, to be told that you have the right to remain silent and the right to counsel. Okay, so that's pre-arrest. So we've already dealt with arrest, all right? What about trial rights? All right, what about trial rights? Now, when it comes to trial rights, you have the right to remain silent throughout trial. Right? You don't have to take the stand in your own defense. Right? And on top of that, all right, the prosecutor, let's say you're the defendant, you're not going to take the stand in your own defense. The prosecutor can't say, and if he or she were innocent, they'd get on the stand and tell you so. Right? In other words, you can't wake up the jury, right, and or the judge, depending on whether it's a jury trial or a bench trial, and remind them that, hey, yeah, this person's letting their attorney do all the talking, but they're not willing to get up and say they didn't do it. Okay? So again, you always have the right to remain silent. You only have the right to be told you have the right to remain silent upon arrest. All right? And during trial, you don't have to say a thing. Right? Prosecutor also cannot call you to the stand. Right? You have the right during trial as well. Okay, let's look at double jeopardy. All right, now this is one of the, maybe 10, 15 years ago, I was teaching criminal procedure routinely. This was kind of a funny issue because there was a movie entitled Double Jeopardy that was legally incorrect across the board. All right, so anyway, it's like, oh, wait a minute, if I didn't kill the person, right, and I did some jail time, can I kill him again? Can I kill him then and say, hey, I've already got credit? So, no, it doesn't work that way. Okay, now, so let's talk about double jeopardy, all right? Now, double jeopardy really does nothing more than protect you against a second prosecution for the same crime, but in the same jurisdiction, all right? Second prosecution, same crime, in the same jurisdiction. Okay, now, here's where things get tricky, okay? Now, let's say I kidnap you, right? I kidnap you in Medina. I take you to Akron, right? I'm in the same state, right? Let's say the state of Ohio prosecutes me. My defense is you consented, something like that. Okay, they can't prosecute me again. Let's say they prosecute me, I'm convicted. Ohio still can't prosecute me again, all right? They already won. One prosecution. Okay, now, let me throw the curveball in. Let's say I kidnap you in Medina and I take you to Akron. Kidnapping is also a federal offense. Okay? Now, can I be prosecuted by the state government and the federal government? The answer is yes. Okay. Does it matter whether I was convicted or not convicted in state court? Doesn't matter at all. All right. So let's say I was not convicted in Ohio court and convicted in federal court. Yep, that can happen. Okay. Clear my throat here real quick. Okay, now let's say I take all of the whole class, or I'm going to kidnap you in Wadsworth, Ohio, and I drive you to Canada. Okay, so I'm going to kidnap all of you and drive you to Canada. All right, I can be prosecuted in Ohio and Pennsylvania and New York and in the U.S. federal courts and the Canadian courts. All right, so double jeopardy, a lot of people think it's much broader of a right than it is. It really isn't much. Same crime, same jurisdiction, okay? But let's say, again, I steal, I kidnap the whole class in Wadsworth and I drive you to Niagara Falls on the other side, all right? Let's say I escape conviction in Ohio court, Pennsylvania court, New York court, right? Could I still be prosecuted in U.S. federal court and be convicted? Yes. Let's say I escape all American, right, jurisdictions in terms of prosecution. I beat it in Ohio, then also beat it in Pennsylvania, then also beat it in New York and in the U.S. federal courts. Can I be prosecuted in the Canadian courts? Absolutely. Okay. All right. Now, so again, double jeopardy protection is really not as broad as most people think. Now again, most crimes are within a particular state jurisdiction, and you don't get into too much of that. But you think about kidnapping or bank fraud, wire fraud cases that also happen to be federal crimes. You generally have two bites at the apple if you're the prosecutors, be it the state as well as the federal. And it does happen. Every now and again you'll see somebody that defeats state conviction and they wind up being prosecuted in federal court. Okay. All right, let's look at the grand jury indictment. Okay, now, when it comes to the grand jury indictment, we need to talk a little bit about what the grand jury does and then talk about what the tool the indictment itself does. Okay, now the grand jury is not a trial jury. We'll spend more time talking about the trial jury when we come back on Wednesday and look at the Sixth Amendment. But a grand jury basically decides whether the prosecutor has enough evidence to go to trial. That's all the grand jury does, right? They decide, hey, prosecutor, we think you do or we do not think you have enough evidence to go on to trial, okay? Now, you have a Fifth Amendment right to a grand jury indictment in U.S. federal court. If you'll recall, this is one of those constitutional rights that does not apply to the states. It has not been incorporated. Okay? The Supreme Court at no time has said states must adhere to a right to a grand jury indictment. Now, at the federal level, you really only have a right to a grand jury indictment in felony cases, and which of course includes death penalty cases. All right? Now, outside of the federal right, different states do different things. Okay? Some states actually require a grand jury indictment for felonies and misdemeanors, right, the lower category of crimes, and some states don't require them at all, okay? Now, there is one curveball there, right? The Supreme Court has said there is a right to a grand jury indictment in death penalty cases. Okay. Now, let's talk a little bit about what happens during a grand jury hearing. The prosecutor basically provides evidence to the grand jury saying, this is what I've got, and then asks functionally at the end, do I have enough evidence to go to trial? Just trial, not whether to convict, just trial. Now, the indictment, the instrument, is based on a probable cause standard, right? Not beyond a reasonable doubt. It's a lower standard because you just want permission to go to trial, right? So think about it this way, right? The prosecutor asking the jury, is this reliable evidence leading a reasonable person to believe that a crime has been committed more likely than not? All right? That's all you're asking. Now, what a lot of scholars in political sciences have pointed to is that perhaps maybe the grand jury is not very fair. The defendant has no constitutional rights to be present or even know that the grand jury hearing is taking place. So you could be the target of a grand jury investigation and never know. All right? And it's been criticized for that. All right? It hasn't been changed or altered. All right? But you might just, hey, one day you find out you're under arrest and there's a grand jury indictment. You've been indicted. You didn't even know. You had no right to know what's going on. All right? Okay. Now, there's a lot more to a grand jury indictment process. There's the process, and we don't need to go any further. Okay, so let's talk about the actual instrument itself. The indictment is really just permission for the prosecutor to take you to trial, right? The indictment reads as really a list of criminal charges whereby the jury has said, yep, there's probable cause there. Doesn't mean you're going to get convicted, right? The evidence could be overwhelming or it could just be barely at 51%. All right? And functionally what happens if the prosecutor is able to get a grand jury indictment, which you've done as the prosecutor, as the state, all right, or the federal government, whoever the prosecuting entity is, they have actually attached the criminal defendant to the criminal justice system. So in other words, once you're indicted, it's underway. You've been charged. All right? And most prosecutors can use an indictment if it's going to be a close call in terms of the actual prosecution. So the prosecutor says, you know, I know I've got probable cause, but I don't know if I've got evidence beyond a reasonable doubt, then that's when the plea bargaining really kind of takes place, and you kind of see where things might end up. All right, but again, and this has also been one of the criticisms of the grand jury indictment process, is that you're actually tying somebody to the criminal justice system with a standard of evidence that's lower than beyond a reasonable doubt. But then, of course, otherwise, the counter argument is, well, that's the whole reason we have a jury process, right? Whereby a jury of the defendant's peers can actually determine whether there's sufficient evidence or not. Okay. Okay. Now. What we'll do now is we'll go ahead and stop here with the due process part of the Fifth Amendment, all right, and pick up from there. So we'll stop there. Good luck on your exams. You take those Monday here in a couple days, and then we'll pick up again on Wednesday. All right, see you then.